here in State versus Shannon Swanson. That's 2014 CR 705, appearing on behalf of the State of Ohio, County Prosecutor Nicholas Irochi and Assistant Prosecutor Cecilia Cooper. And the defendant is present in court with her attorneys, Angelo Lonardo and attorney Leonard Ambrose, who is from Erie, Pennsylvania, and has been admitted in this case pro hoc. We're here on the defendant's motion filed on January 15th, 2015, pursuant to Rules of Criminal Procedure 12C1 and C2 to dismiss the indictment based upon the effects in the institution of the prosecution. We ready to proceed, counsel?
On behalf of Dr. Swanson, yes, Your Honor.
All right, and Mr. Irochi?
Your Honor, on behalf of the state, we are not ready to proceed. As we've said in chambers, and yesterday we received notice of this hearing yesterday afternoon, which was a state holiday. Have not had the opportunity to have any witnesses or really any time to review a 100-page document that was provided to us on the 15th at 3:30 or digested in any reasonable fashion.
All right, well, the issue here is very simple. What was the defendant's mens rea when she is alleged to have committed these offenses? And they have resulted in a 52-count indictment. And I certainly believe that the prosecutors should be able to explain to the satisfaction of the court what was the criminal intent of this defendant, so your request for continuance is denied. Okay, Mr. Lonardo, are you ready to proceed?
Yes, Your Honor. As set forth, Your Honor, in the motion to dismiss, which was filed on January 15th, 2015, that was filed, Your Honor, pursuant to the motion that we filed, the defense filed, to extend the deadline to the 15th from, I believe it was the 13th, as we are new defense counsel in the case, and we saw this as a motion that was essential to a fair resolution of this case. Judge, state briefly, the motion with the attached exhibits is stating that based upon the evidence set forth in Exhibit A, which is the indictment itself, we're saying that we have established and shown a prima facie case that this indictment is defective. There is insufficient evidence for submission to the jury based upon the face of the indictment. And that's a rare situation, Judge, but that's exactly what we have in this case. And under the Fifth Amendment, Dr. Swanson and all citizens are entitled to the return of an indictment in which probable cause is shown of criminal conduct, of culpability, of criminal intent. That's the whole purpose of criminal statutes, not just in Ohio, but in all 50 states and in the federal court.
But bear in mind, this case has been to the grand jury twice. I reviewed it personally, and I reviewed it when it was first presented to the grand jury, and then when we were getting ready for trial the last time. I'm sorry, I did not review it last night.
She's practicing medicine in Pennsylvania. Obviously, she needs her income to support her family. So we have two states. Pennsylvania is saying, we're going to renew your license. She voluntarily gives up her license pending a resolution of this case. They want her back. But you know, you hit on something really important, the issue of consideration. That would be absolute circumstantial evidence of intent. That's what it would be. You can go to any hospital. I don't care whether it's in Erie, Pittsburgh, Cleveland, Metro, university hospitals. This happens. There's no intent to sell or attempt to sell any drugs.
Well, I'm just going to put everybody out of their misery. I'm going to grant the defendant's motion. These charges are dismissed, and I'm sure you're going to see each other a lot in the Court of Appeals and maybe the Supreme Court of Ohio. I think this is a case of prosecution overreach, and I had that impression the first time the case got filed. I studied enough law to read what was going on and knew enough about the facts of it, and then, of course, it comes back a second time. So the charges are dismissed.
We believe that dismissals were proper. There was no basis in fact to return the indictment against this hardworking physician. There was no consideration. There was no evidence of intent to violate the law. Therefore, we agree with the court's ruling completely.
I don't have a problem with you giving a jury instruction on the subjective state of mind, if it's requested.
Okay,
But the objective state of mind has to be considered also.
Fine, tell me the subjective state of mind of this defendant that is the criminal mens rea that results in these 52 counts being brought against her. What is the criminal intent that you know of other than merely the writing of the prescription? Tell me what it is.
She intended to give these prescriptions away to her friends for no good medical reason whatsoever.
What? They are medical people. They are colleagues of hers, both at Andover and Lake Erie Correctional Institution, and they complain of either an obese woman complaining of being overweight and someone having sleep problems.
And nowhere in the rules or regulations of the physician's rules or in the directions for giving prescriptions does it accept friends or people you work with. It says they have to be patients, you have to keep records, you have to examine them, and then you prescribe medication. None of that was done in this case, and it was done intentionally.
Well, I don't know how you get around, Your Honor, the Supreme Court dictate. I mean, it specifically says a physician unlawfully issues a prescription not in the course of bona fide treatment can be held guilty of trafficking. I mean, period. It doesn't say anything in here about consideration being required. It specifically says if she or he unlawfully issues a prescription, which happened in this case multiple times, particularly to someone she never saw who lived in California.
What cases do you have where there has been no consideration given to the physician or the medical person or the pharmacist who was charged?
The case that Ms. Cooper cited, State of
1982
Ohio versus David Black.
Yeah, that was a 1982.
Your Honor, we've had 1 day to prepare for this hearing.
Wait a minute, this case went to the grand jury 2 different times, and I
Yes, it
started to
did.
research this the first time.
We
And it
had
went to the
plenty
grand
of
jury.
research
Yes,
based
you
on
be
the
quiet
Supreme
when I'm
Court.
talking. I researched this the first time, and I was familiar with the McCarthy case. So I'm prepared on it, that's why. And this is for the prosecutor to come in and say, I need more time to be able to explain to you what the criminal intent was after the case has been presented twice to the grand jury. I don't buy it.